What's up, everybody? Welcome to the live. Everybody show me what's up. Hit the like button. Let everybody know we're here. We're going to be talking about a bunch of things today. There's news in the Jay-Z lawsuit. We finally heard from the judge. Judge Torres has finally weighed in on Tony Buzbee's lawsuit against Jay-Z and Diddy, but mostly it's about Jay-Z that we're all talking about here, because he's the one whose lawyer has been filing a lot of motions. So we're going to be talking about that here. Hi, Mike. How's it going? Thank you for saying hi. Everybody hit the like button. Let me know where you're from, too. I'm building out the channel. You can check out the memberships. And I've got a handful of members here. We're still building them up here, but I'm hoping to do a lot more lives, and we've got some good trials coming up. ASAP Rocky's trial coming up in LA. Line from Denmark, thanks for saying hi. We've got, is it Mina M from Jersey? We've got Dia from New York, and Detroit in the house. What's up, Mike? Here comes drama. We've got one of my favorite members. Thank you so much for saying hi, and thanks for tuning in. We've got some news to get to regarding Judge Torres's order in the Jay-Z lawsuit. This is the first time we've heard from the judge since the amended complaint has been filed. James, thank you so much for tapping in. I appreciate it. Cherry from St. Louis, thank you so much. Gotta love Missouri. And Harlem, New York, you're welcome. I love giving out information. Hi from Jamaica. Nice. We've got a real international presence with Denmark and Jamaica represented so far, and a good cross-section of America here. Orlando, Florida. There's always something good going on in Florida, something interesting going on in Florida. Thank you, David, for tuning in. We've got some news to get to regarding the Jay-Z order. You guys, I don't know how you found this live, if it just showed up in your YouTube feed. I think that's how most people find it. But I did post earlier today on X the order from Judge Torres and let everybody know I was going to be going live. So if that's how you found it, then here we are. But we'll get to the full order here, but the gist of it, and overall, this is pretty incremental. Like, I think if we actually talk to Alex Spiro, like if this is the lawyer, Alex Spiro, who filed this for Jay-Z, he represents Jay-Z, and he represents a lot of high profile defendants. He's currently doing work for Elon Musk, etc. And he represents a lot of different celebrities, but let's pull him up here. You all might recognize him as Alec Baldwin's lawyer, and that was at least it was the first time for me that I was actually able to see him in action. So yeah, as Here Comes Drama said, hit that like button. But he is a bulldog, and he really took a proactive approach to these filings once Jay-Z was named as a defendant in the amended complaint. And I think if we actually talk to Alex about some of the requests that he made to the judge, I think he knows that the chances of them actually being granted, especially the one about he wanted her to shorten the window, the waiting period for filing a motion for sanctions. He wanted her to shorten that from 21 days to 1 day. And I think if you actually ask him about that, he'd have to acknowledge that the chances of that actually happening, of her actually going for that, were like slim to none. Like, I don't think he was filing those requests necessarily because he thought they were being granted, but there was a big PR tactic of it. He was using the filings to respond to the interviews and the media coverage of the Jay-Z lawsuit. So I don't think he actually thought that was going to be granted, just because, like I said, I mean, the whole idea that she was shorting the window from 21 days to 1 day was kind of ridiculous. But she called him out on his tactics, said Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks are inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast track the judicial process merely because counsel demands it. And I think for a lot of people who pay attention to federal courts and especially just looking at this judge's background, none of this is really surprising. But I don't think Alex was really filing this stuff for her. I mean, he was filing this stuff for the public. But one misstep, arguably, that he might have made here is, well, I don't think his request to shorten the filing window from 21 days to 1 day, I mean, I don't think that had a chance of being granted. The one that seemed like it could have been granted, that he did have some law in his favor on, that was his request that the plaintiff have to identify herself publicly, because we've seen that order issued in other lawsuits against Diddy. Although I do think that the order that Judge Clark issued in February 2029, which is actually cited by Judge Torres in here, and that's the order that says the plaintiff suing Diddy has to identify herself, that came at a different time in the litigation. There wasn't so much attention on it, etc. I mean, just the amount of attention we're having, and then the tone of some of Alex's filings. I mean, you can kind of see why the judge here thought that it's just a different situation now, and that right now the factors favor anonymity. But she emphasized that it's a temporary situation and that she could revisit and change that. But you wonder if the judge, it's hard to say. I mean, hopefully she just made that decision entirely on the merits. But she obviously was pretty turned off by Alex's tactics. So you kind of wonder if he hadn't done all the other stuff, if she would have had a different approach to the anonymity request. But he definitely lost that one. The one that she hasn't ruled on yet, though, is he did do a request for Buzbee to be ordered to preserve evidence, which implying that because the lawsuit is, BS, Buzbee is going to destroy evidence because he had bad ethics. And she hasn't rejected that. She actually set a briefing schedule for it, and he has until January 10th to file his reply, and then Alex can respond after that. So we'll bring up the order here in a second, but thank you just for, thank you. I'm so happy to say hi to the fans. I was actually going through my merch. I still got some merch left, some Meghann the Reporter and Googly Eyed Bitch merch left, and was like, I need to promote this stuff better for my fans. But if you guys go to MeghannTheReporter.com, I've got some like sweatshirts and like stickers and mugs. The mugs are the most popular. But let me see here. It says, can you speak on why can't get, and it's getting the same traction? I think those, I don't know. I'm just ignoring that. I mean, I just think it seems weird. I mean, and I can kind of see why. I mean, celebrities are just like, why? I mean, why anyone who asks for a DNA test, why would they have to take it? I haven't really paid attention to that one. But obviously, she didn't shut the door on his motions for sanction. His motion for sanctions. She says that he could file one. She's not going to shorten the window, but just her tone in this, he could file one, but it's not going to be granted. So it definitely looks like, I mean, from right now, the case is proceeding. His media's request was that she strike the amended complaint, which if she had done that, I mean, the case would pretty much just be over. I mean, Diddy or Jay-Z wouldn't be a defendant anymore, but she didn't. So now it just goes through the basic litigation process. But we'll say, I think, I can definitely see the concern about the court of public opinion and the need to protect a reputation and everything. And Alex Spiro has been talking about how this is, such a matter of such dire importance. But I mean, one of these lawsuits against a celebrity, this sex assault lawsuit, actually went to trial recently, in the last couple of years, and a jury found him liable for sexual abuse, and the country went on to elect him president. So, I mean, the idea that one lawsuit that hasn't even been to court yet at all is just going to tank Jay-Z's reputation and like everything that he's built over the last 25 years. I mean, realize it's easier said than done when you're not the person accused, that kind of thing. But I mean, I just feel like, and especially around this time of year, I mean, while there is, obviously we're all here talking about it. Anytime I post about it online, it gets a ton of attention, but the massive public at large is so big. And I just wonder how much they're really hanging on all the back and forth. You know, the idea that these statements and all these filings are just tipping the public scale back and forth. Like, I think the mass general public, the last time they probably remember seeing Jay-Z is maybe at the Grammys or the Super Bowl. Those were like his big public appearances. And then there's, you know, a much smaller like group kind of watching this. But I just feel like the idea that this one lawsuit from Tony Buzbee is just ruining his reputation. It's like, but it's going to be around for a while. So we'll see. I mean, like I said, like legally I think Alex's stuff succeeded in the public relations realm. The idea that he ever actually thought a lot of this stuff was going to work, like his request to shorten the window, his request to strike the complaint completely. I mean, all that stuff would have been pretty out there to actually have granted, but there was definitely a public relations pull behind it. So thank you. I love you guys too. Aren't they aware of who the attorney is? Yeah, that's a good question. They implied in their last filing that they weren't. Well, I think they just straight up said that they don't know who it is, because Alex was saying that the father is a witness and that they want to talk to the father because, you know, we all saw the NBC News report where he said that he doesn't remember picking her up. And part of her story is that her father picked her up in the pre-dawn hours before after this all happened back in 2000. So Alex's letter was saying that they need to interview the father and they don't know who it is. But like in this other case of anonymity that's actually cited in this order, Judge Clark's order in this other lawsuit against Diddy, the lawyers do know who it is. And this is the lawsuit where the woman just identified herself as the like ex-wife of a football player. But when the litigation was going on over about whether she should identify herself, Diddy's lawyers filed something warning, basically saying, hey, if we can we file some stuff under seal about why we want her to identify herself, because we're worried that the arguments that we're making about why she should identify herself are going to identify her, like, because she's a public figure. So it was just the lawyers being like ultra careful and not wanting to do anything to identify her, like, until there was actually a court order saying she had to identify herself. So that made it clear that Diddy's lawyers in that case knew who she was. It was just a matter of, are they going to make her, identify herself in public? And I think the argument for that was there could be witnesses coming forward, et cetera, et cetera. So the judge ruled in their favor on that. But in this case, like I said, there's that recent filing from Alex Spiro that says one reason they need the woman to identify herself because they want to talk to her dad and they don't know who it is. So that indicates that, unlike Diddy's lawyers in the other case, they don't actually know who she is. But that could change. But Mixed Chick, thanks for coming in. We've got a member in here. Here comes Drama and Mixed Chick. Couple of members here, a couple of early members of the Legal Affairs and Trials with Meghann Cuniff. But so yeah, here's Judge Torres's order here. See if I can get it a little bigger on the screen. And I've also got the PowerPoint that Alex did. I wasn't at the media presentation because I wasn't in New York City, but I've got the actual PowerPoint that he did explaining why the lawsuit is BS. But I think in the court of public opinion, like I said, all that stuff is really good. And I think if you talk to Alex like privately. He had to have known that a lot of these requests, I mean, at least a couple of them, the one to shorten the window from 21 days to 1 day, that wasn't actually going to be granted, but it had a real public relations effect on the whole thing. But the request to identify her is one that I think really could have gone either way. So I'm wondering if all the filings that he made that kind of turned off the judge obviously hurt him in that regard, but hopefully not. She goes over her reasons here. But yes, everybody hit the like button and share if you can. Let everybody know that we're here. Some people, I'm like a good year and a half into the YouTube channel, year and 4 months, and I still get people saying I have no idea you had a channel. And for a while I was just doing all YSL clips, but I'm trying to do more lives to let people know what's going on. So again, here is the 5-page order. So this is Analisa Torres. This is the first time we've heard from her since the amended complaint was filed. She did do an order previously, and when it was just against Diddy, and that was an order saying that the plaintiff could proceed anonymously. And I know I've seen a lot of comments online saying that the judge is being really unfair because Alex was just responding to Buzbee's own tactics, and Buzbee is the one who's been going around, stirring the pot and going on TV. But I think what's notable about her order is she doesn't cite any TV interviews beyond the NBC interview, but she's not like scolding anyone for the NBC interview. She's just focused on the filings in front of her. And if you actually look at the filings, all Busby has filed is the amended complaint, which obviously that's the problem with Jay-Z. I mean, with Jay-Z and Alex Spiro say that that's the problem and he should be sanctioned for it and everything. But I mean, as far as lawsuits go, especially in this day and age, there's all sorts of stuff getting filed. So all Busby has filed in this case is the amended complaint naming Jay-Z, and then he filed a letter responding to some of the stuff that Alex had filed. So Alex is the one who has filed a bunch of stuff asking for kind of unorthodox changes to court rules and that kind of thing. So, I mean, I can see why people are upset that it seems like Alex is just defending Jay-Z and responding to the own kind of like ambulance chasing tactics that he's seen. But in terms of the court, Busby has not really filed anything other than like an amended complaint, which those are pretty freaking common. I mean, we see all sorts of crazy lawsuits filed, and then just a letter responding to Alex's stuff that's like actually pretty measured, but we can bring that up here. So the judge says, plaintiff filed this on October 20th, alleging a violation of the New York City Victims and Gender Motivated Violence Protection Act. And that's the law that we've seen cited in so many other sexual assault lawsuits being brought against Diddy, including, I believe it was cited in Cassie's lawsuit that settled quickly after. But says, by order dated November 6, 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. On December 8, 2024, plaintiff amended her complaint to add Sean Carter, known professionally as Jay-Z, as a defendant. Plaintiff again sought to leave to proceed anonymously, but this time Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to the federal rules of civil procedure. Carter also moved for an expedited hearing on the issue. The next day, Carter's attorney filed a letter containing a declaration from an associate at his law firm recounting a phone conversation she had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of sexual assault. Carter's lawyer asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegation against him. On December 13th, 2024, attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. In the interview, plaintiff speaking anonymously, explained her allegations against defendants and her reason for coming forward now. Carter's lawyer points to the interview in which plaintiffs admitted to inconsistencies in her story as evidence that plaintiff's claims, quote, have no factual basis whatsoever. He also argues that plaintiff's counsel violated federal rules of civil procedure by failing to undertake a reasonable inquiry into the facts before filing the complaint and failing to seek admission pro hoc viae to this court. Carter's attorney requested an expedited briefing schedule for motion to strike the amended complaint under federal rules of procedure. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F. In deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to defendant. The Second Circuit has laid out a non-exhaustive list of factors to be considered. Whether the litigation involves matters that are highly sensitive and of a personal nature, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity, whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age, whether the suit is challenging the actions of the government or that of private parties, whether the defendant is prejudiced by allowing the defendant to press her claims anonymously, whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court, whether the plaintiff's identity has thus far been kept confidential, whether the plaintiff's interest in the litigation is furthered by requiring the plaintiff to, whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity, whether, because of the purely legal nature of the issues presented or otherwise, there is an atypically weak public interest in knowing that litigants' identities, and whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So, and she just says here, the weight of the factors tips in favor of allowing plaintiff to remain anonymous, at least for this stage of the litigation. She says factors 1, 2, 4, and 7. So 1 is highly sensitive in personal nature. Plaintiff is particularly vulnerable to possible harms of disclosure, particularly in light of her age. Her identity has thus far been kept confidential. And what was it? 4, 7, and 8? 1, 2, 4. Whether identification poses a risk of retaliatory physical or mental harm. Interesting. Or to innocent non-parties. It says in her amended complaint, plaintiff alleges that defendants drugged and raped her when she was only 13. Courts in this district have recognized that allegations concerning sexual assault are highly sensitive and of an extremely personal nature. Plaintiff is extremely vulnerable to the possible harms of disclosure. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her sexual assault. Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claim to have been threatened by Mr. Combs for their decision to speak out. And finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously. Granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government, and given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. And this is citing Judge Clark's order in the other Diddy lawsuit, where she actually orders the plaintiff to identify herself. But this judge viewed the facts in this case differently. But it says alternative mechanisms may exist to protect confidentiality, namely the redaction and sealing of documents. Most importantly, plaintiffs' continued anonymity may cause prejudice to defendants, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge plaintiffs' credibility. She's quoting from Judge Clark's order in the Diddy case. She says, identifying the, quote, most significant form of prejudice to defendants as the discovery disadvantage that plaintiff's anonymity would present. She said, the court does not take such prejudice lightly. Nevertheless, at this exceedingly early, and that's the thing, it is so early, it was just freaking filed. At this exceedingly early stage in this case, the factors counseling against disclosure outweigh those that counsel in favor. Requiring the plaintiff to, and she's quoting another lawsuit that says, requiring the plaintiff to identify herself as the case approached trial. Accordingly, plaintiff's motion to proceed anonymously is granted. Plaintiff is advised that because the balance of these factors will certainly shift as this case proceeds, especially if and when the parties engage in discovery in earnest, this court intends to revisit this decision at a future date. Remaining motions, and this is when she gets a little pissy about all the filings. So since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding on the purported urgency of this case. She quotes one describing plaintiff's counsel as self-promoting and accusing him of extortion. She quotes another that requested to be heard on an expedited basis and accused plaintiff's counsel of exploiting the legal process to generate media attention. Takes one to know one. Asserting that plaintiff's counsel seeks only to benefit himself. Requesting the shortening of a deadline from 21 days to 1 day. Yeah, that was just like, it took some nerve. I mean, like I said, there's no way he could have actually thought that was going to be granted. Isn't he a Harvard law grad? Describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of all attorneys and requesting a hearing on a motion the following day. Carter's lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. Moreover, although Carter's attorney assails plaintiff's lawyer as having a, quote, chronic inability to follow the rules, Carter's counsel has failed to abide by this court's clear rules. Under the court's individual practices in civil cases and with limited exceptions, a pre-motion letter is required prior to the filing of any motion. Although Carter's attorney stated that he intended to file immediately a motion to strike the first amended complaint, he did not give plaintiff the requisite 5 business days to respond. And the rule says, wait for the court to set he didn't give the plaintiff the requisite 5 business days to respond, wait for the court to set a motion schedule, or state whether any exception to the court's individual practices applied. This is unacceptable. Counsel is hereby advised that any further motions filed in violation of this court's individual practices may be denied on that grounds alone. So what does the footnote say? Sometimes the footnotes can be kind of spicy. It says, on the merits, Carter's motion to strike is denied. Motions to strike under Rule 12 are generally disfavored and will be granted only if there is strong reason to do so. Carter's motion, which summarily asserts that plaintiff's claims are baseless and salacious, does not clear that high bar. So yeah, that's good. Yeah, I mean, I just see TJ's comment. Exactly. Weren't these filings mostly for PR? Yeah, no, they were. The only one that I think really had a chance of being passed was his stuff of asking for the plaintiff to identify herself. And he might have kind of screwed himself on that by pissing off the judge with all these other filings, but it's hard to say. She really has pretty wide discretion on that. And while I thought, it favored them identifying herself just with the previous order from Judge Clark and Diddy's case. Also, the situations have just changed. There's so much more public interests on this now. And he actually has not lost everything too, because she has not yet ruled on his motion to order Buzbee to preserve evidence. And she set a briefing schedule for that. Buzbee has until like January 10th to file a response. So he could get somewhere with that. But yeah, I think you're right. They were just filed for PR, especially his one asking to shorten the window from 21 days to 1 day. It was like, and then he had filed a few things and she had not responded to anything. And he filed something on a Wednesday afternoon that asked her to hold a hearing at Thursday morning at 9 a.m. It's like, okay, he has to know this stuff isn't going to be passed. And the thing is that while he clearly annoyed the judge and she issued this ruling scolding him, I mean, the idea that this means that, you know, it's just over for him and she's going to have it out for him and all the rulings going forward. Like, no. I mean, if it's the case is as bad as he says it is, and there's no merit to any of it, he should have an easy time going through the process. They just have to actually go through the process. But the idea that the judge is going to like hold some grudge against him, you know, but I was kind of thinking it's like in any other workplace, if you did this kind of work product and your supervisor, which I guess the judge arguably is, it's the one that you're trying to like persuade, comes back and tells you like your work is inappropriate and is actually not helping your client. Like you'd think there would be some kind of consequence like within the workplace because of this, but there's no way we would ever know. I mean, it's really just between Jay-Z and Alex Spiro and the people who are like the other partners at the law firm. Like as long as Jay-Z's paying his bills, they really don't give a shit. Like, I mean, especially because some of this stuff is like the defamation claims that they're filing. A lot of this stuff is clearly just filed for like public relations stuff. You know, they're all just kind of destined to lose on litigation grounds. But so this is the sanctions motion. It says, lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of court, the court discourages this approach. If he still intends to serve plaintiff with a motion for sanction, the court denies his request to shorten the safe harbor provision contained within Rule 11C2 from 21 days to 1 day. She says Carter's motion to strike the amended complaint under Rule 12F is denied. By January 10th, 2025, plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. By January 17th, Carter shall file his reply, if any. So that's where we're at. The preservation of evidence that was alleging that if there isn't a motion, if there isn't an order in place, Buzbee's going to be destroying stuff to cover up his tracks or something. But now, the only thing we've heard from Busby in this case is the letter that he filed. I'll bring it up here. I'm going to do, if you guys go to legalaffairsandtrials.com, I'm trying to spruce up the Substack more and do a lot more with it. But I'm going to send something out tonight that sums everything up and has a link to all the documents. But if you guys go there now, the story from a couple days ago has everything linked in here and kind of a back and forth between them. And this is still when she had not addressed anything. But let's see here. One thing I did get, I've got the PowerPoint and I've also got the video that here. This is the video that
alleged accusations against Mr. Carter. The timeline and details that Jane Doe has provided
that Spiro made
do not create a scenario in which any of the accusations are plausible or possible. Time doesn't lie. These accusations bring to question all details of the complaint, the reasonable timing of each moment, and how this all could have happened, which is irrefutably not possible. In her complaint, Jane Doe states these points. She snuck out of her window and had a friend drive her to the VMA location, Radio City Music Hall. To get to the after party, the drive from the VMA's residence was 20 minutes, that the driver had to drive Diddy to the after party first from the VMAs, then come back to get her to bring her to the after party, that Diddy and Mr. Carter were at the residence by the time she arrived, that after the alleged sexual assault, she navigated through the party to the exit and ran to the nearest gas station to call her father to pick her up, and that her father picked her up before dawn. To establish all of these alleged timings and make sense of a plausible timeline, we've started with the facts to understand the start and end to the alleged incident, which did not happen. Jane Doe, on the day and year, lived in Rochester, New York, over a 5-hour drive without traffic to Radio City Music Hall. The VMA's broadcast and show started at 8 p.m., which Jane Doe claimed she watched outside on a jumbotron. She would have had to leave her home at 2 p.m. to get to Radio City Music Hall on time to watch celebrities arrive, she claims, and be there for the start of the show. Jane Doe claims that her father picked her up before dawn on September 8th. Dawn on that day was at 6:29 a.m. For her father to drive from Rochester to pick her up, the latest the phone call from the gas station would have had to have been at 1:30 a.m. That establishes the start and end to our alleged timeline. Now let's work through the facts. The VMAs in 2000 ended at 11:11 p.m. Jane Doe said that the driver had to drive Diddy to the after party, come back to get her, then drive her to the party. She also stated that the drive was 20 minutes. That in total would have been 20 minutes times 3, which is 1 hour total of drive time. The earliest the driver could have picked her up is at 11:51 p.m., making the earliest the driver could have dropped her off at the alleged residence is 12:11 a.m. Irrespective of the details of the residence, this now establishes that the earliest she could have been at the residence is 12:11 a.m. Now, for her to call her father from a gas station at 1:30 a.m., we have to establish how close is the gas station from the residence. Out of the possible locations for the white residence, the nearest gas station is 42-minute walking distance. That means that the latest that Jane Doe could have left the residence after the alleged incident is 12:48 a.m. That creates 37 minutes for this 13-year-old girl to be at the party, talk to celebrities, have a portion of a drink, and for the alleged sexual assault to happen. For her to run out of the house, be in an area she knows nothing about, knows no direction as to how to get anywhere in the middle of the night, and find her way to the nearest gas station 42 minutes away to call her father to pick her up. This is all assuming that everyone left exactly on time at 11:11 p.m. once the VMAs ended, that there was no traffic after the VMAs in the 3 drives the driver made to transport Diddy and Jane Doe to the party. This is also assuming that Diddy and Miss Lopez did not attend any other after parties in the 1-hour period before Jane Doe arrived to the party, and separately, Mr. Carter either, and that without any directions in the middle of the night in an area she is unaware of, Jane Doe made it on foot to a gas station in 42 minutes. This is all not possible and irrefutably false. This alleged incident and timeline are not plausible, and this did not happen. This timeline is absolutely not plausible, as both Diddy and Miss Lopez are photographed at other VMA after parties at commercial establishments at the time in question, and separately Mr. Carter as well, none of which are the described white residents in Jane Doe's complaint. In these pictures, you can see Diddy and Miss Lopez change clothes from the VMAs, went to multiple commercial nightclubs, including Lotus and Twirl, and none were the White House described in Jane Doe's complaint. This incident did not happen. Now, to speak on the white residence that is described in Jane Doe's complaint, she describes it as a large white residence with a gated U-shaped driveway, and she says it was 20 minutes from Radio City. There are no houses matching Jane Doe's allegations within the 20-minute drive from Radio City Music Hall. To dive deeper into the details, there are 2 possible residences in Diddy's life during that period of time, but none match Jane Doe's description. There's a Manhattan townhouse that does not match the description. There's a Hamptons home over 2 hours drive away. There are 2 residences in New Jersey. One was sold in 1998, years before the alleged incident. One was purchased in 2004, after the alleged incident. In fact, there is no home in Manhattan gated with a U-shaped driveway. All in all, time doesn't lie. The location of Jane Doe's alleged incident does not exist. The alleged timeline of the incident is not possible. Diddy and Miss Lopez were at other after parties at commercial establishments during the time in question. And separately, Mr. Carter was also at other after parties at commercial establishments at the time in question. This event is provably false and did not happen.
Okay. So yeah, that was a presentation that Alex Spiro gave to reporters. I think it was last week. That hasn't been filed in court, but I mean, if you look at that, it's like, well, they're pretty well ready for depositions, discovery. I mean, that's almost like the beginning of an opening statement right there. So just regarding what the process is from here, I'm not sure if it means that she's celebrity B. I think it just means that Diddy was with her that night. So yeah, that still hasn't been identified. But let me pull up. It's the only letter we've heard from Tony Buzbee on this whole thing. He's only filed one thing. He filed the amended complaint, and then he's filed one letter responding to everything here. It's filed under this was filed back on 3 days ago. It's always just, it's that really weird time of the year where you don't even know what day it is. But yes, if you just got here, please like and share, and let us know where you're from in the chat too. We've got a good international crowd, and thanks to all the members out there too. I'm building up the channel, getting new members, so check it out. But this is the only response that Busby has filed, or oh wait, excuse me, this is the wrong case. This is another. This is Diddy's criminal case. Excuse me, I can't keep all my stuff straight here. Let me pull up the right order here. Okay, here's the Diddy case, or the Jay-Z lawsuit. And this is it. This is the letter from Busby that was filed back 6 days ago. He says, as with defendant Carter's prior letters filed in this case, it is histrionic in tone but substantively groundless. Defendant Carter threatens plaintiff with a Rule 11 motion based on questions raised by one single television interview concerning events occurring 24 years ago when plaintiff was 13 years old. Defendant Carter also asked this court to alter the federal rules of civil procedure in his favor by abrogating the mandatory 21-day Rule 11 safe harbor period without any legal support or factual justification whatsoever. The former is frivolous and the latter is impermissible. Defendant Carter's threat of a Rule 11 motion is frivolous because it characterizes run-of-the-mill disputes of fact as proof that plaintiff's complaint is baseless. None of the factual issues Carter identifies are sufficient even to grant summary judgment in Carter's favor, much less support Rule 11 sanctions. And just from a legal standpoint, like based on everything we've seen in that video, it's true. But that doesn't mean that it's a good case. It's just, I think if you hear a lot of those discrepancies, I don't think a lot of lawyers would have filed a case like that. I mean, because I think although most cases like this don't go to trial, especially a case like a celebrity like Jay-Z, you think you would file it with trial in mind. And it seems like this has problems. But again, as the judge said, it's really early in the process. But it says the fact that the defendant or a potential witness does not agree with or recollect the facts alleged in the complaint does not and cannot give rise to a motion for sanctions for filing a baseless complaint. Defendant Carter's threat of an immediate sanctions motion on the first whisper of factual uncertainty is just one more instance of bullying, intended to have a chilling effect on plaintiff's counsel, and any potential plaintiffs watching these proceedings. As a Rule 11 motion is frivolous on the additional ground that expecting a victim of sexual assault over 2 decades ago, when that victim was a minor and, as her interview revealed, also autistic, to have perfect recall of all facts is outrageous. Defendant Carter twists plaintiff words when he accuses her, for instance, of guessing at the timing of events alleged in the complaint, such as the length of car rides. But New York courts have expressly acknowledged that plaintiffs in this type of case cannot be expected to have exacting recall and command of all relevant facts. We recognize that in matters of sexual abuse involving minors, as recounted by survivors years after the fact, dates and times are sometimes approximate and incapable of calendrical exactitude. That's a quote from another court ruling, in approving allegations spanning a 4-year window of time in which the abuse could have occurred. So yeah, a 4-year window of time. And that's a case against the Roman Archdiocese. Says there is no basis for a Rule 11 motion here, and if filed, such a motion would itself be subject to a Rule 11 motion in response. Of course, we cannot prevent Defendant Carter from wasting the resources of this court and all parties in pursuing one. However, Defendant Carter's request that the court shorten the filing deadline for his threatened Rule 11 motion from 21 days to 1 day is entirely improper. Carter fails to cite any precedent whatsoever to support this astonishing request, because there is none. Carter also fails to cite any reason why the federal rules of civil procedure should be abrogated in his favor in this particular case. Again, there is none. The 21-day safe harbor under Rule 11 exists to provide parties and counsel time to assess the objections being made and to withdraw or modify a pleading or other paper if necessary. The safe harbor period has been recognized by the Second Circuit as a strict procedural requirement. It cannot be shortened here because Mr. Carter and his counsel request as much, whether in an attempt to play gotcha or to exert additional pressure on plaintiff or for any other reason. So, again, this is what Judge Torres just responded to today and ruled basically in Buzbee's favor. Thank you so much for reading my newsletter. I appreciate it. I'm enjoying the Substack life and encouraging you all to subscribe to my Substack, and paid subscriptions keep the blood flowing around here. So I appreciate it. My goal is to really build that up this year. If I can, really get a paid subscriber base, I could get over to New York for Diddy's trial, that kind of thing. But if the judge determines that the complaint is false, what will happen to the accuser in Busby? Well, it's going to be, because the trier of fact in this case would be the jury. So the idea that the judge is just going to be able to rule that all this stuff is BS. I mean, Busby is technically right in that regard, in that right now the problems that have come up, well, I think it shows that not a lot of other lawyers would have filed that lawsuit. The idea that it's not grounds for a motion for sanctions, and he's probably right that it's not ground for summary judgment yet. I mean, I'm not quite sure what we would see in that, but remember, the lawsuit against Trump went to trial and ruled in his favor, but then there was also, or ruled against him, ruled in E. Jean Carroll's favor. But there was also that lawsuit against Kevin Spacey, Anthony Rapp's lawsuit, and that went through the process for a number of years. And I actually know the attorneys who represented Spacey on that, and they would tell you up and down that was just made up BS and et cetera, et cetera. But it went all the way through the process and went to trial. No, this is a different suit. I'm talking about the Kevin Spacey, Anthony Rapp lawsuit that was tried in Southern District of New York Federal Court. I'm not talking about the England case. That was a different case that was tried after after the Anthony Rapp, Kevin Spacey case. But this is, I mean, Anthony Rapp, Kevin Spacey is pretty much the exact same. I mean, same court, different judge, similar claims. I forget what year Anthony Rapp said it happened, but that was a lawsuit in the Southern District of New York, and that went to trial a couple of years ago, maybe now. But the jury ruled in Kevin Spacey's favor on that. But in the other case, the E. Jean Carroll's lawsuit, also in the Southern District of New York, different judge, but I think same courthouse, the jury ruled in E. Jean Carroll's favor. So, I mean, I don't think there's really a stage in like the legal proceedings for summary judgment. Like if the judge has to leave like big factual determinations like that to the jury. So it'll be interesting to see what the actual summary judgment and dismissal motions are based on. Yeah, you can definitely get a in the U.S., especially, I mean, federal court, state court. You could opt for a bench trial. I mean, I've seen bench trials, both criminal and civil, but I see a lot of federal civil trials with juries, and really, especially when I was at the Daily Journal, the LA Daily Journal, the newspaper for lawyers and judges. I mean, there were like 12 or 15 reporters, and one reporter's full-time job is to cover criminal law, and everyone else covers some variation of civil cases because that's how big and busy civil law is. I mean, criminal law is actually just a really small kind of sect of the law, which is kind of fucked up because it's the most important one. It's the one that the public sees all the time, but that's not where, you know, all the money and attention is in law. It's all in civil cases. So yeah, civil juries are extremely common. The thing is, like, and that's one thing, that the courts are so clogged up. Like, none of this really worked. And I mean, like I said, I don't think Alex Spiro actually expected a lot of these motions to work, but they didn't. And then he's got that other lawsuit, the defamation lawsuit that was filed against, let me bring that up, because he just amended his lawsuit in LA Superior Court, the one that they had filed back in they filed this back in October under a John Doe name against Buzbee, alleging extortion, and they just amended it to include a defamation claim. And they're also asking for an injunction to prevent Buzbee from making any more defamatory statements. The first court hearing on this is not even really a hearing. There's going to be a case management conference. It's not even scheduled until May. That's in like 5 months. I mean, he's looking for an injunction. The judge isn't even going to like have this on calendar for 5 months because these guys have so many other cases that have been filed. There's a similar lawsuit, a defamation lawsuit that Leah Remini had filed against Church of Scientology that just in the last 6 months or so got through demur, like kind of like a dismissal motion, a different form, but went through the demur process. And that I think was like 18 months after it was filed. And I think it's eventually going to trial, but not for like a couple of years. Because, I mean, in the end, most of these civil cases, and this is why private judging and mediation is so popular and growing, is because the courts are completely clogged. And people who actually have legitimate legal disputes that they want to get resolved will just go into private mediation. Because if you have clients that'll pay for it and you're willing to agree to binding arbitration or something like that, you can get stuff resolved quickly with an experienced jurist who's like a retired judge or something, and you don't have to deal with like a 3.5 year wait that you see in the courts. But the problem is it's all private. It's not like reporters can just go check the JAMS filing and see who's going through private mediation. So what you get is all the stuff that's being filed in public court. I shouldn't say all the stuff, but a lot of stuff being filed in public court. There's a very big public relations aspect to it, because that's why they're willing to not actually have a hearing on their injunction for, 5 months or something, because everything's filed and it's a big public relations thing, and they actually kind of maybe actually don't even really give a shit about the legal dispute they're trying to resolve. But there's just such a public relations aspect to everything. But yeah, it's crazy how clogged the court systems are, especially state court. This defamation lawsuit, like I said, that Jay-Z has now filed against Buzbee. I mean, like I said, maybe something will happen that they'll move up the court date, but right now they're not even scheduled to go to court until May. And this is the response they got from the judge in the other case in federal court. But here. But like I said, I mean, I was saying earlier that I think reputation-wise, Jay-Z can withstand this right now. That we're just going to have to kind of wait for the process to play out here. But Tony Busby is definitely not backing down. I noticed he posted something on his Instagram stories. He had like a photo of himself on Christmas Day, and here, let's pull up his page. Oh, prime rib. There you go. But yeah, he hasn't said anything. He hasn't posted anything else about the case. No, what? That's that. Yeah, there you go. Yep. So, yeah. So I'm going to put together something for the Substack mailing list that has the video and everything and links to all the new court documents. So if you guys go to legalaffairsandtrials.com, get on the list. I'm going to be doing more with the Substack in the next year. But if you guys want to show me a subscribe, and speaking of clogged courts, yes, that's another thing. ASAP Rocky is going back to trial in next month. It's like January 18th or January 21st or something. Yeah, because that's a Saturday. Yeah, it's like January 21st or something like that. Jury selection starts. So that's going to be big, and that's another thing I've been kind of looking ahead to. I had to do some stuff for that today, but that's going to be kind of the next big thing to cover. But if you guys go ahead to legalaffairsandtrials.com, give me a subscribe. You guys can get all the ASAP Rocky news. And then actually I need to do something. I've got all the footage from his preliminary hearing, and I should kind of repackage it and do a trial preview, because it's got all the evidence kind of laid out in there for everybody. But yeah, if you guys all subscribe to my Substack, you can get my summary of the latest in your inbox. And thank you so much. Shout out to the replay crew too. Whoever's watching on replay, I appreciate it. And Girardi, see, I've got the news on Girardi there, right there. If you guys go to legalaffairsandtrials.com, his sentencing was vacated last week because he is going to North Carolina to undergo a it's like a mental exam. And then Otani's interpreter is next month too. It's like January 24th in Orange County, and that's going to be big. I mean, really, of all the media circuses I've been a part of, the Otani interpreter stuff is the craziest, because Otani is such a big international star. And it's, God, for the guy's sentencing, it's going to be huge. All the Japanese media that'll be there, and for his guilty plea, there was a huge contingency there, and some guys were getting like super aggressive with him, like getting right up in his face and stuff. So yeah, that'll be a big one. But I would not expect there to be much going on with Busby and Jay-Z, at least in this particular case. It sounds like he says that, or he's told Jay-Z he has other accusers, because Jay-Z has revealed that in his own filings, that they were threatening him with allegations involving a male. So we haven't heard anything about that. But I'm not sure how much time is going to be requested for Otani's interpreter for stealing from him, but it's probably going to be a lot. They're probably going to throw the book at him. And the judge on it, Judge Holcomb, it's like his first big high profile sentencing since he's been on the bench. And I don't think he's exactly like going to go easy on him. So he could get like over a decade, I think. But we'll see. But yeah, so thank you all for tuning in, and consider becoming members if you can. I'm going to keep updating people on what's going on, but it would be awesome if you guys could subscribe to the Substack and spread the word and give me some more paid subscriptions on there. It's my goal to really build that up over the next year in 2025. And yeah, prison calls. I've got a lot of things going on here, so I'm gonna sign off here and get cracking on the thing. So thank you. Here comes drama. You're such a loyal supporter. I appreciate it. And if you guys are on TikTok, check me out on there too. I made a little video going over the latest here. So thank you all so much for everything. And I will see you guys later, hopefully sooner than later. Thank you.